Looks like everyone is ready. We are now here in the case of State versus Boone. Mr. Sease, you may begin.
Thank you, Your Honor. May it please the court. As mentioned, my name is Matthew Sease, and I represent Maurice Boone in this matter. Today, we ask that this court reverse the district court and find that the court should have granted Maurice Boone's motion to dismiss because the state failed to meet its burden to prove that the statute of limitations was tolled in this case. We ask that for two reasons. First, this court should find that 802.6 subsection 1 should apply only when a defendant leaves the state of Iowa. And
Sentences there. That doesn't seem so obvious to me. When a person leaves the state, blah, 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 it gets told, comma, and no period during which the property charged was not publicly resident. Aren't there two things we need to look at?
I think there's two ways to look at this statute, and the way that I've had it broken down in my mind is that there's kind of two steps that the statute outlines. The first is when the trial information or indictment may be found, and that is when that individual returns to the state. Now, then when that individual returns to the state, you have to do the calculation, and that's what the second part of that statute applies, and it's telling you how to calculate it. But it still is all under that purview and that context of that very first clause when the defendant leaves the state of Iowa or leaves the state.
Client did leave the state of Iowa. I think there's a phone call with him acknowledging Texas and showing a license plate that he was in Texas.
He did leave the state of Iowa, and where the issue arises then, if we look at that second part of the statute that tells you how to count, the state was required to prove that he was out of the state for 501 days. And that's what didn't happen in this case. He certainly had even admitted that there were other times during that 501 day or that 3 and a 4 or 5 year time period that he left the state, but it was occasionally.
Saying that he has to be out of state for 501 days, doesn't that completely ignore that clause of publicly resident? Resident means in the state. Doesn't that completely ignore it and wash it away?
Does any more so than finding that public only means, or public can mean both inside and out of the state, would wash out the whole first half of the clause, because it requires, it wouldn't be necessary to have that first half of the statute.
A third possible reading, if he's out of the state and he wants to come back and restart the statute of limitations, then he needs to be publicly resident in the state, not in hiding or whatever.
That's probably a way to interpret it, but the state has the burden to establish that he was not publicly resident, and that's what was really lacking in this case.
But I mean, publicly resident, publicly means to me, how could the public find out? I was trying to fathom what else could the officer or the detective looked into to try and find a footprint or a fingerprint of him somewhere in the state. Food stamp records, child support records, driver's license, workforce development. Pray tell, what else is there public out there that should have been tapped? Taxes?
I think it's just normal police work that happens on the ground and in that area and continuing to be in that area where they suspect that person to be.
Back to where? To his mom's house? And
initially, the time frame is very unclear as to how much Detective Youngblood or any of the other Des Moines police officers actually did for that. He said initially he had a couple of conversations with family members or acquaintances, and they didn't say that he was out of state. They didn't say they knew where he was, but they weren't providing it. It was simply, I don't know. And that's the problem with it, is that there wasn't any indication as to where he was. And the state has the burden to prove where he was or what he was doing.
Someone might not be publicly resident if their own friends don't know if they're here?
I think part of the issue is that we don't know what those friends actually knew or didn't know. They certainly weren't sharing it with law enforcement, but the fact of whether they knew or not, I think, is a different question. They weren't cooperating with law enforcement at the very least.
I mean, isn't that enough for the state to meet its burden? I mean, there's sort of an initial burden. They showed that the brothers said they didn't know where he was. The lawyers said he didn't know where he was. He later said, well, I intentionally worked off the book so I wouldn't pay taxes. That's illegal conduct that would help him from being detected. He intentionally didn't get a driver's license so he wouldn't have to pay child support. That's also potentially illegal conduct. Isn't that enough to meet the state's burden? And then if he wants to come back and offer some proof that he was publicly resident, he's welcome to do so. But, you know, the state, it seems to me, maybe met an initial burden.
I don't think that they have. And the problem is that they didn't establish what Mr. Boone was doing before these criminal charges happened, right? There wasn't anything saying that he took all of these steps after the crime happened to conceal his identity or anything along those lines.
Sorry, they can't even find the guy, let alone what was his plan before he left. I also want to comment, Justice Waterman, or Mansfield made the comment, and he could, you know, come and say what he did do once that burden shifts. And aren't I correct that the district judge found him to lack credibility when he did give his explanations?
Absolutely did, and he did present evidence to rebut that, and the district court judge said that he wasn't credible, and that's why I'm not necessarily arguing that. I think his testimony was somewhat unrebutted, but my point is that the state didn't establish that, and if you by simply saying they don't know where he is, well, that's not enough. I think there needs to be something to show that he was actively not being in the public.
If it walks like a duck,
Sure.
be persuaded that he was resident. I mean, what didn't rebut? I think everything the state put on was not rebutted, and if it was found not to be credible.
I don't think that it's necessary to show that he was publicly resident. I think that the state has to show that he was not publicly resident. And if the standard is you don't have to pay taxes, or if you're not paying taxes, or you're not asking for food stamps or something like that, there is a whole swath of people that will not have a statute of limitations apply to them.
What was he lacking in?
I think he should have had more boots on the ground or taken a more active investigation. The alternative is to prove some sort of active concealment that happened as a result of these charges or when he was put in warrant.
Distinction between being a resident and being publicly resident.
I don't know, other than the dictionary definition. And the dictionary definition, it just merely says open and available to people. So
Being publicly resident must be something more or in addition to being a resident?
I think that is one way to interpret it. But if you don't have to have that.
Publicly mean, if you think there's a legal distinction between being a resident and being publicly resident, then what's the difference? Unless you're just saying publicly means nothing.
I think resident requires there to be living in that state, and so you have to be open within that state. So I think that's probably what public means. So if you're a resident within a state, but you're just traveling through there. So let's say that you have a border individual that is driving back and forth between the Quad Cities on the Illinois side and the Iowa side, right? And he commits a crime in Iowa. That person's not gonna be publicly resident because they live in Illinois, but they are publicly within the state.
I mean, so assuming you're a resident, that you believe your home state is the state of Iowa, that's where you live, that's your domicile, whatever you want to call it, what's the distinction, the legal distinction between resident and publicly resident?
To go back to the dictionary definition of that, and it does add that qualifier. So you might be right, Justice McDonald, that was.
Argument I believe you were the district court lawyer, correct? Okay. These are your words I'm going to cite you on. This was the motion to dismiss, and you both got to give a closing argument to the motion. And you said, I appreciate Detective Youngblood and the state's efforts to try to locate Mr. Boone. I am not accusing them of being non-dilatory in their actions. It's simply he had to have been out of the state for 501 days. So aren't you making somewhat of a different argument today?
I am, because the crux of my argument before the district court and really today is to interpret this statute as a requirement that the individual has to be out of the state of Iowa. Now that what we've talked about and what you've asked me about is what Detective Youngbook did falls more into my alternative argument of even if that public resident doesn't require you to be outside of the state. But the crux of my argument and what I've always maintained is that the statute requires the individual to be out of the state of Iowa.
We require the state to prove to show publicly resident. What is good enough in your view?
In interpreting this statute, Justice McDermott, that the state has to prove that the individual was out of the state for whatever amount of time is necessary to toll the statute of limitations.
It could be here and a resident of Iowa and just not publicly resident here, right?
With that,
Hiding out in a basement and having food brought down the stairs for 3 years, that's not enough.
is under the plain meaning of the statute and the interpretation of the statute. And I think if you look at the legislative history, and I've cited and we've talked about it a little bit, this language has essentially been in here for 150 or 170 years. And the title at that time, all the way up through 1978, all involved the defendant being out of the state. Right, and so specifically between 1924 and 1978, the title was "Absence from State Deducted," and it.
Something more, according to the legislature. We want to add another prong. Isn't that actually an argument that they added to it?
I don't think so, because they did not change the publicly resident language. That language has maintained and remained the same from 1851 all the way till present,
And with the intention of hiding or something like that?
2002, when they modified the statute, because it was when the defendant left the state with the intent to conceal or avoid or something along those lines. And then there was a couple of cases from this court that said that if the state wasn't able to prove that actual intention element, just merely being out of the state wasn't enough. And so the legislature removed that particular section of the statute.
Just as a matter of, I mean, the big question is about surplus, right? I mean, is that surplus? But it seems like your argument makes the whole publicly resident phrase, those two words, entirely surplus, because it says, no period during which the party charged was not publicly resident within the state is a part of the limitation. Now, you take out publicly resident, and it just says no time when they were not within the state. That's your meaning.
And that's what it is. And I think when you look at, as I said, the legislative history and the first quarter of that sentence of the first part of the statute, it says when a person leaves the state, that's correct. And I think that the problem that I have with reading publicly the way that the state has requested the court to do it is that it eliminates the whole first part of that statute.
What I'm saying is just take out publicly resident and then you get to your meaning. Is that fair? Yes. Okay, so we have to find it surplus.
Yes. And I think that that's right, and I think that it's when you read the statute as a whole and look at the legislative history, it has to apply only when the defendant leaves the state. That's
Not going to say that's surplus. Let's assume that the court is persuaded that that means something. How does your guy end up?
I think then we fall back to that secondary argument of mine, my alternative argument that the state didn't meet its burden.
What else are they supposed to do? Give me an example. Tell me some ideas of what, other than combing through public records and physically going to mom's house and checking with his sibs once in a while.
To do it in a more frequent basis than what was alleged and what was testified to in this case. Simply doing it once and then saying, hey, I put it out there that we're looking for this guy isn't sufficient. And if
What's that statement, doing it once? Doesn't the record show that he put it out on bench warrants? Excuse me. He let other officers know. He continued to communicate with family.
I don't know For the record is exactly clear how often or how much he actually did any of that, Your Honor.
To the family, even annually, let's just say annually.
I'm not sure annually is sufficient either. I think it needs to be a more intensive search that happens, and I don't know if the record actually establishes how much Detective Youngblood actually did in this case, other than what his cursory testimony was. Thank you.
Good morning. May it please the court. The court must give full effect to the legislature's words. Maurice Boone was not publicly resident in Iowa, so the statute of limitations did not expire. I think there are two questions of statutory interpretation here. First, about the two clauses of 802.6 sub 1 being separate extensions, and the second is giving a meaning to the word publicly resident. So with the first question, the two clauses in there are separated by punctuation, separated by an and, indicating they're separate. But not only that, their plain language gives different triggers, and they give different periods of extension. And critically, that is what makes the two operate differently. They overlap some in some circumstances, but if the person leaves the state, under that first clause, it's not a day-for-day reduction. It is a restart of the 3-year limitations once they come back to the state.
Counsel, the district court ends up saying that during this time period, defendant was either out of state or hid his residence. And I think I kind of interrupted you when you were trying to lay out your scheme, though. But I was a little curious as to whether that's the kind of finding that district courts need to make, he was sort of that either or does it need to be more specific for each prong?
That's kind of a belts and suspenders ruling, but primarily the state in this case was arguing the extension under the second clause, the public resident part. So obviously, if somebody is not living in the state, they're not a resident of Iowa, period, but also not a public resident of Iowa, for sure, under this evidence.
I think one way or another, sort of the district court's belt and suspenders approach, one way or another, he doesn't get the benefit of extra, or the state does get the benefit of extra time. Is that the?
I think that goes to kind of the impossibility of meeting the defendant's standard in this case is if somebody has successfully evaded law enforcement is diligently searching and has been unable to find the person for years, how is it that the state is ever going to prove that while they were missing, they were in a different state as opposed to being hidden in Iowa? So
to the burden then, who has the burden? Does the state have the burden to prove that he was not publicly resident, or does the defendant have the burden to prove that he was?
it's the burden on the state to prove by preponderance that he was not a public resident, which proving a negative always presents some problems. But given the legislative intent that this statute, this public resident clause has meaning, I don't think they intended to make that an impossible burden for the state.
Response to opposing counsel's assertion that, and I'm not sure what the record is as far as like how many times Officer Youngblood went to the address that they had for his mom. How many times, is annually enough? How do we establish or determine what is enough to determine whether or not someone is publicly resident with respect to, talking to family members?
Case by case. And in this case, it was pretty clear that that avenue of asking family was growing cold, but the detective still followed up. And again, he didn't document, date by date by date every interaction, but he did make
Like the public database kind of information, or follow it up with like actually surveying the residents to see if they could see him coming or going? Which kind of follow-up are you talking about?
So the record supports that there were multiple discussions with both brothers over the years, trying to find out where Mr. Boone was. There were multiple, on I think it's page 18 of the transcript, the officer says he made occasional checks over the years at workforce development to check those kind of public indicators. And then he's alerting the officers who are in the area of the defendant's residence to be on the lookout for him. And once...
Sorry, are the public indicators enough to satisfy the state's burden? If all they did was look to see whether or not he was paying taxes, getting food stamps, renewing his driver's license, would that be enough without going and checking his residence or talking to his family members?
Could be, and again, that it's not something that we have to get into in this case because the officer did all avenues.
Hypothetical to you, Mr. Hanson. So walking back from the Y this morning on the skywalks, I ran into a couple of homeless fellows. It's winter, it's cold. There's, some people that are trying to stay warm. Are they publicly resident in the state of Iowa?
I don't know enough from that kind of brief introduction, but there's nothing preventing somebody who is homeless or somebody who has mental illness from getting a driver's license. There's nothing preventing them from registering to vote.
Have a driver's license or voter registration. And that wouldn't necessarily help the detective find them, would it?
It could, and even if they don't have those sort of indicators, if they are well-known enough that they're known to be in the skywalk at certain times of the day, or they're known to live at a certain encampment, if it's something that a reasonable officer exercising reasonable diligence is able to find them, then that's an indication that they're living publicly. If they are in hiding, whether it's, and I shouldn't say hiding, if they're unreachable, whether it's purposeful or not, the legislature can make a reasonable judgment that the statute of limitations should not run. And I think there was a discussion from opposing counsel about the officers should have put more boots on the ground. Well, the legislature's already made that policy choice, and a statute of limitations is an act of grace by the legislature. It's not required by any constitutional provision. So it's up to the legislature to set the bounds of it. And they can make the reasonable judgment that when people are really hard to find, whether it's purposeful or not, that the statute of limitations should not run, because the state has a burden, not just in this case to find this individual, but to continue investigating all the new crimes that are coming in. So,
Certainly continued with his brother, is that correct? Same crime, different defendant?
he was charged, he was arrested, the officer was able to find him. He ultimately pled guilty, and he served a sentence, all while Mr. Boone was on the run still.
This language, this publicly resident language, goes back to the 19th century, right? And it's interesting that we're sort of saying he wasn't publicly resident because he wasn't on various, driver's license and public support programs, all of which are creatures of the 20th century and beyond. And is there any tension there, or should we think about that situation when it was originally enacted and how it might be different? Does that have any influence on our analysis?
That what a public resident looks like today is probably different than what it was in 1851. However, of all the other states who have this same provision, the same language in their statutes, they've had no problem adapting it to the modern era and what it means to be public.
1951, what did this officer do that probably would have been similar to what would have been done back then? Or what did he not do that someone back then could have done?
I think the main thing is going out to where the person was known to last live.
Taxes were probably owing back then too, maybe? I don't know. But
Going out to where they have clues where he might be, talking to people who knew him, friends, family, those sorts of things, are all things that would have been done in the 1850s that were done in this case.
Sort of like the Second Amendment, it's not just muskets. The language of publicly resident is broad enough that it can sit there and just wait for developments over time, and then whatever we judge to be publicly resident at a specific point in time, based on our society. Is that fair?
It's consistent with, for instance, how we interpret the Fourth Amendment. There are technologies today, GPS trackers, things like that, that have no true analog to the founding times. So how it interacts with today's society does change.
There record evidence that he was affirmatively trying to stay below the radar when he was back in the state, and what is that?
Yeah, so it's not just that he didn't have those blips in kind of public residency, like income taxes and jobs and things like that. It's that he wants the court to believe that coincidentally, he just happened to stop doing all those things in 2016. So he had a job with a traditional paycheck, and then it stopped in 2016. He had a driver's license, but then he stopped renewing it. He had public assistance like food stamps and Medicaid, and then he stopped. So that certainly indicates an intent to evade those sorts of indicators of where he might be, but also just the timing of when he initially left the state. So it's when it took a few days for the detective to kind of track down the main suspects. But once he did, he made contact with Mr. Boone, said, "I'd like to speak with you." And then the next day, Mr. Boone is in a completely different state. And never after that returns to public life in Iowa.
he was always in the state of Iowa except 2 days here, 2 days there for vacation. Is that correct?
Testimony. It's also forgetting that there's approximately 200 days from the time he's arrested in Nebraska until he's actually returned to Iowa and indicted.
From his arrest? No.
He was arrested March 13th of 2020 in Nebraska. He had charges that he had to resolve there, and he's not back into custody. So really, we're talking about 301 days from when that initial 3-year limitation would have expired until he's covered.
Trial court's credibility determination that he didn't have any?
A preponderance standard, and we're looking at this level for substantial evidence to support the district court's findings. And
Started with an overview of how you thought the statute worked. I thought I had a pretty good grasp on it, and now I'm not so sure. So could you continue that? So you said the first clause means when somebody leaves the state, you think it refreshes the entire statute of limitations.
initial 3-year period, moves to Minnesota, leaves the state completely, no ties here. Then when they come back in, it says, the information or indictment may be found within the period of limitation prescribed in this chapter after the person's coming into the state.
Moves away 2 years and 6 months after allegedly committing an offense. They go away for 2 years, they come back. The statute of limitations, the full 3 years starts again. Okay, so then what's the second clause? How does that interact?
Is independent of that. And I mean, that's been recognized since 1882. This court in McIntyre, which I provided as a additional authority, addressed a similar argument.
So you're saying if somebody allegedly commits a crime in Iowa and at sometime within the limitation period, they go to Kansas City for a weekend and then come back, the whole limitations period starts over?
Yeah, I think leaving the state would have a different interpretation than just a temporary visit out. And that's how other states interpret their similar provisions that usually in public.
Leave for any period of time, it just says leaves. I mean, it seems to me it's more logical to read it as tolling the time period when they're out of state, doesn't it?
The limitation prescribed in the chapter starts after the person coming into the state is actually from the 1851 statute. Even though the trigger has changed, it's from that time. And the trigger back then was when the person was outside of the state when the crime was committed. Then when they came back, it restarted. So they are separate. The McIntyre case resolved that question, and Mr. Boone was not publicly resident in Iowa, so this court should affirm the denial of his motion to dismiss.
Justice McDonald, were you done? Did you want to finish? Okay. All right, thank you.
Thank you, then.
Go ahead, Mr. Sease.
Thank you, Your Honor. I wanted to start with just briefly addressing how other states apply similar language. And the state outlined in their brief several states that have that similar publicly resident language in their criminal statute of limitations and tolling provisions. The problem is that in each one of those states, none of them have the qualifier of when an individual leaves the state or has anything even similar to the first section of that statute in it. And in fact, there's at least one state, I believe it's Montana, that has a little additional information, but in that specific legislative history, it quotes language that's very similar to the Model Penal Code that says that this is to be interpreted in a manner where you can't reasonably ascertainable place of abode or work within the state. So the Montana legislative history specifically says that. And in effect, what the state is asking the court to do is read the Model Penal Code language into that publicly resident. And that's not the case. If the state wanted to adopt that language, they certainly could have. It's part of the Model Penal Code. It's available. And the Model Penal Code language is, just like I mentioned, it's told when there's it's not reasonably ascertainable place of abode or work within the state. So if that individual can't be reasonably ascertained or they can't find their work within the state, then that statute of limitation is told. But we don't have any language even close to that. And what the publicly resident language means under the dictionary definition is open. And in my mind, when I think about that, is Mr. Boone doing things like going to the grocery store or living out in the open? That's all that we have to establish. And if the state,
Anything like that.
I had to establish that, Your Honor. I think that the state has to establish he's not doing those things.
Shifted. Let's say the state put on enough evidence to say, hey, we've tried and we are plumb out of luck. We just don't know. And then your client did testify. Did he say anything to try and prove, like, hey, I was registered in school or whatever it may be? What evidence was presented to the court to rebut the state's?
That we would have to do that, and that would be inconsistent with the case law if we ever had to present any evidence of that. But
You put on evidence.
yep, and I put on Mr. Boone's testimony, and that's all we had.
To persuade the court that the state was wrong.
It was incredible, but he said that he had lived in the state, lived at a couple of different addresses. He had a cell phone.
But never articulated the names of those 11. What did he articulate, though? Not just general statements, I was here.
He articulated anything specific other than, I think he gave a couple of specific addresses that he was at and the people that he was living with.
Well, are you asking, or is this imposing on the state kind of having to prove a negative then? And how are they supposed to go about proving a negative?
I don't know if it's necessarily that they're disproving or proving a negative, but maybe they are, and that's what I am asking, is that they aren't, or they have to establish that he was not acting out in the open, and he wasn't living out in the open, and however they do that, they do that.
to me they put in some evidence of that. There's evidence his own family doesn't know where he is. That's unusual. That would suggest he's not publicly resident. Most people, their relatives know where they are, right?
The problem with that is that we're relying on information that his family members are providing to law enforcement to make that determination.
Leap to assume that family may not be terribly cooperative with the officer in trying to find him?
Exactly, and that's my point of why that type of evidence is questionable.
Our reasonable hat, and just the facts of this case are a crime was committed within, I think, 24, maybe 48 hours at the most. Law enforcement contacted your client and said, hey, we want to talk to you. And then he got a lawyer, and then he was evaporated from any purview of anyone else. Isn't it reasonable to assume, and his brother was at the same incident and actually served 7 months in jail, I believe, isn't it reasonable for us to assume, to make that next leap, he's hiding?
You can make that assumption, Your Honor, but the problem is I don't believe that satisfies the burden of the preponderance of the evidence to make it more likely than not. You still have to establish it with evidence, and that's...
I mean, tell me what else, give me a good example of what the state could have or should have presented that would say, slam dunk, public resident. No.
And I think the problem that I have with the state's evidence, and I think it goes back, I see my time's expired, I'm assuming I can respond. Thank you. Yeah, thank you. What I have and what the issue that I have in this case is the way that the evidence came in and the way that it was presented. And if they had established evidence...
That's not the question I asked you. Give me an example of something that you would have to say, yep, I wave the white flag.
I'm sorry, with...
Something that your guy or the state could have presented as evidence that would have been more persuasive than what they did.
I think that they needed to establish his residency in another state, and not even residency, but his presence in another state for whether it be the 300 days before he got picked up in Nebraska versus the 500 days.
Justice May's comment that the language is surplusage because publicly resident is within the state of Iowa. Would you agree with me?
I agree that with the caveat in that in making that rule or that ruling and that determination, it makes the whole first half of that statute superfluous also, and that's the problem. My version makes it less.
Does lenity apply and help you here?
And I think that was outlined in Walden and in the Tipton cases that these, I don't know if it's definitively called the rule of lenity, but these are to be liberally construed in the favor of the accused. Okay, thank you.
Versus Boone is hereby submitted, and we are going to take a very brief recess, just like 5 minutes or so, and we will come back for Sutton versus Council Bluffs Waterworks.